we have a quorum, even though it's a pretty thin quorum. Welcome everybody here today. Out of deference to better looking than most of the men up here, but certainly not to one of our female members, we're going to call Representative Rakestraw up today to do House Resolution 913. It will be.
Hear me now? Oh, thank you. Okay, so House Resolution 913 is a study committee, and right now it says a House study committee, but we're actually going to be asking that you approve this as a joint study committee, and we'll be getting language from Ledge Council. So that's the only thing that will change, is it will say that it's a joint study committee. So there's an emerging area of law enforcement that is doing pre-arrest diversion programs, and that is to arrest people that have issues with mental health and addiction as they encounter them, and to do outreach programs. And I don't know, do y'all have this in your folder? So this is the Police Treatment and Community Collaborative, and it's brought together several organizations that are for this. It's new and pretty emerging. Fulton County has a pre-arrest diversion program, and there's only about 500 out of 18,000 police and sheriff's departments in the nation that are doing this at this point. And so, you know, since Georgia's so cutting edge and you know, always on the front end of good ideas, I thought that we should lead this. And so there are 5 pathways, and so each pathway is something that I think needs to be studied, and we need to flesh out operationally. We need to look at where they can go for treatment, because we don't have near enough treatment in our state, and just, you know, look at how we can improve and give the police another tool in their toolbox to put people where they belong when they need treatment instead of jail. And you know, some of our jails are actually bringing mental health services into the jail, but it's really not where they belong. And I think we can have better outcomes and results if we start to divert people where they need to be into treatment. But we do need to look at it and study it comprehensively in terms of resources, funding, and kind of lead the way on doing something statewide. So there are 5 pathways. One is self-referral. If someone raises their hand and says, hey, I need help, then they can help them get into treatment and do a warm handoff. Active outreach is, you know, they arrest these people over and over in the community, so they know the people that have issues, so they can reach out to them in a non-crisis moment and ask them, you know, would you like treatment? If they revive them with naloxone plus is a good time when they're probably in a moment of willingness, ready to get help, to offer them treatment. Officer prevention, if they're out on their beat and they encounter someone that is not necessarily involved in a crime, but they see that there's a mental health and or co-occurring addiction issue, they can offer them treatment. And then the last pathway is officer intervention, where they are able to, if there's a low-level non-criminal or low-level offense, they can hold their charges in abeyance while they complete a treatment program. So it's just a very good proactive, preventative way to work with people and try to get them the help they need, so that we're not filling our jails. And so I think this is an idea that bears studying and fleshing out, and I would appreciate your support for it.
All right, and my understanding is you've agreed that to make this a joint House-Senate
Yes, sir.
study committee.
Yes.
All right, Julius? On Resolution 913, Representative Rakestraw's bill, we're going to change this from a House study committee to a joint study committee.
Thank you.
And there's going to be a little bit of cleanup work we're going to have to do. All right, 5 members of the House. What do you want to reduce that number to? 3 from the House, 3 from the Senate?
Works for me.
6 members, 3 from the House, 3 from the Senate. And then all of the other needed changes that'll have to be made grammatically of changing all where you see chairperson to the co-chairs, and let's see, reports will have to
Okay,
be
there are more
filed.
changes than I was expecting in the bill. I thought we were just going to change that one thing, but there's details. So, okay, yeah, so it'll be co-chairs, 3
Yeah,
per.
you get down on line 43, and there's probably a few other places in here. Reports will have to be filed, where it's currently clerk of the House. It'll be clerk of the House and secretary of the Senate's office. Line 34, have to add appropriated from the state Senate. I think Julius knows what all you need. What's the will of the committee? Do y'all want to wait and get it printed up, and we'll have another meeting this week? A short meeting?
That might make sense. Then we,
All right,
that'd be fine.
all right.
Then we can move.
Mr. Chair, is there anything in here,
Yes, ma'am.
Mr. Chairman, is there, I'm trying to read it quickly, is there anything in this bill that is showing any type of professional services in order to start this study committee? Who's actually, have experience in the mental health and the drug awareness part? We're studying it, but who's actually educating the members on what we are actually doing?
That would be, if it's like most study committees, that'll be done by anyone who wishes to testify or that's called to testify by the committee members or the co-chairs. All right. Any other questions of the committee? All right, Julius is going to prepare a substitute committee sub on this,
okay,
and then we'll let you know, because we'll probably have a short meeting later on this week.
okay, great.
Right.
Thank you
Thank
so
you, ma'am.
much.
Let's see. All right. Mr. Deffendahl. Before you start, the chair wants to thank Representative Deffendahl for handling a couple of these bills. He just became part of the Powell caucus.
It's a good group to be part of.
Helped me move out some of these things that I've been weighted down with. If you would, 855, go right ahead.
You're on 855, is that
Yes,
the
sir.
one you're
Yes, sir.
wanting to do first?
Yes, sir.
Yeah. Okay, Mr. Chair, this is a bill to increase from 1.5% to 3%, I'm sorry, 3%, the effective fine increase that's available, and it's to be used for driver training. And where right now the House has several other bills that are being suggested or tried to be processed on distracted driving. And I think this is an excellent opportunity to catch these students before they even have their license or shortly after they have their license. That would be a much better way of instituting distracted driving practices and habits. They have a 36-hour course for the most part, and it's 30 hours of classroom, 6 hours of driving. They also, I think, want their parents to be monitoring a 40-hour program.
That's correct.
Is it not that they are graded by their parents on their driving skills? So in all these different ways, I think it's a very well-developed plan in order to accomplish that. There's no money for taxes that are added to it. It's added on to speeding fines, misdriving, driving too close, things like that, that will be help financing this program. And I think you were going to bring up something about
Sure.
some of the history.
For the sake of the committee, let me give a little background on this. You know, for years, we've always talked about driver education. Schools were never able to, a lot of the public school systems got out of driver ed over the years. Back in the 90s, there wasn't enough money for them to operate on. The will of the General Assembly for years has always been, and that's to train these juveniles before they get a license so that maybe they'll make safer drivers. And driver ed was something that we were very strong about, whether it was in a public school system or the private schools. Quite frankly, most of us always preferred the private schools because it was no drain on the taxpayers, and it was also, they seemed to be a little bit more professional in the method that the private schools went by. This bill, I think, and if I can remember, search my memory right, in 2005, or somewhere around that neighborhood in 2005, the legislature passed a 5% surcharge that went on traffic violations, and that money was then remitted to the state. But that was during a period of time, for whatever reason, that the administration of that day did not see fit to appropriate that money to driver education. And what we have found at that time for about 5 years or more, that money was going into the general fund, and it was accumulating at that point. I think some 60 to 80 million dollars is estimated went into the general fund of the state and was not appropriated as was the intent of the General Assembly. So about 5 years ago, I'm thinking now, it was up for renewal. And at that time, the committee, at that time, we reduced it because the money was going to the general fund and wasn't being used. Now, some of us that's been around for a while, we've got a pretty bad taste of the fact of all of these surcharges being added to traffic citations, because that's the reason a lot of the traffic citations up. If you think it's $100 fine, then you'll find out when you go through the process it's probably about $170 to $80 fine with all the surcharges. Now, not all surcharges are a bad thing. When we did away with, we took 3.5% off of that and left 1.5% in that went to driver education. And since that time, thanks to the current administration, they have in fact been allocating and appropriating that money as the intent of the legislature to go toward driver education. Thanks to Mr. Blackwood, who is over the Governor's Office of Highway Safety. They came up with a new way of doing this a couple of years ago, and it was in the form of scholarships. And these scholarships are done to the public schools, they're done to private schools, they're done to the tech schools, and it's done on an application process that they submit and ask for these grants. And now we find ourselves, they've been so successful in the last few years of doing scholarships for driver education that they have now run out of money. Plus, I'd be remiss if I didn't tell you that 1.5% has also dropped in value from what they were once, these citations were once bringing in. They're not bringing in that dollar amount.
Correct.
We're estimating right now that 1.5% is bringing in a little bit less than $3 million,
Yes, sir.
and seems to be dropping. Now, one of the reasons we have asked that question, And that's because of the new transit systems. People are more aware of the penalties for DUI and such as that. Plus maybe ride transportation services, even though they refuse to pay their state sales taxes, they have done a pretty good job that the drinking public will get on an app and they'll call somebody to come get them, so that the state patrol's not stopping them, or local officers aren't stopping near as many, because that's only an observation as to why. Bottom line, we're asking for this to be increased a 1.5 to go to 3%. We figured that that's a good area that they can issue more of these scholarships. Is that, Mr. Blackwood, did I do a pretty good job?
You did a very
explaining
good job,
that?
Mr. Chairman. And let me say, this is not an agency bill, but we have no problem with this. And we believe that it will more than double our scholarship capabilities, because we've already paying our administrative costs and so forth out of
Right.
of what we have. We will right now about 5,200 students this year, and we'd love to see that number increase.
Yeah, my calculation, since there won't be any more, this money shouldn't be going for admin, since that's already into place. We're probably looking at maybe as many as 6,000 scholarships, extra scholarships that could be issued around the state for driver education courses. And it would certainly be that student and their parents' decision whether they want to go to a public school or a tech school or to a private school driver ed program.
And the good news, Mr. Chairman, is that we now have, at any given time during the year, within a 30-minute drive of any Georgian, some much less, we have a driver's training program, either public or private, available to students around the state.
Very good. If y'all would stand for questions. Ms. Frazier.
Yes, what's the average cost of what's one scholarship cost?
About $500 is for the public schools, and that varies. Let me say this: they range from about $350 on the low side to about $500. There's some private schools that are less than $500, but $500 is our maximum.
And also, that's just a driving course, but they are responsible for getting their licenses
Absolutely.
and all that afterward. That's just for the initial course.
That's correct.
Okay.
It is a 30 and 6 course. That's 30 hours of classroom time and 6 hours behind the wheel, and then they're expected to complete another 34 hours with parents behind the wheel. And we have worked with the Shepherd Center developing an app that helps them monitor that, and it actually takes them through a checklist, and it's available that's available to anybody for free. And it takes them through a checklist of things they should learn, and to make sure they've accomplished what they should accomplish. And it records the time based on GPS movement of how long they're behind the wheel.
I think also a further explanation of that is that if they complete the course, they get a 10% discount on their insurance.
That's correct.
If they complete the course with a B plus or B
B average.
average, you get an additional 10%. So that's 20% off of your insurance rates with the different companies. So depending upon what that is, what that their expense is by adding a teenage driver, which is not very small. So in a year or two, having this course under their belt, if they drive safely during that time, the course is more than paid for.
All right. Mr. Petrie.
Thank you, Mr. Chairman. Mr. Blackwood, so this increase, this is doubling the fee. This would bring in about $6 million a year,
Yes, sir.
obviously.
Somewhere between 5.8 to $6 million.
Right.
And
So
that number has, and as the chairman indicated, that number has come down, and we don't know.
that may continue.
Yeah,
Right.
it may very well.
My question for you is this: so, what is the average violator? What is the fee? Is there an average that the average violator would be paying if we increase this? What is it today? We're going to double it. About how much money are we talking about for an individual that's paying a traffic fine on average?
If it's $100 fine, you're talking about going from $1.50 to $3.
I understand that. I'm trying to understand what is the typical fine.
I don't have an answer to that, sir.
We have
a
somebody of authority.
we have a winner.
That wishes to be recognized.
In 2011, state audits did an
That's what I'm interested in.
That's, that's outdated by 7 years. At that time, the average fine was $104 across the board.
Okay.
Very good.
104 on average. Thank you.
2011 now.
We have any other questions? Any other questions? There's only one thing I would like for this committee to take a look at on line 2122. This code section will be repealed in its entirety on June the 30th of 2019 unless extended by the General Assembly. I would like to put that back in and change that to June the 30th of 2022.
Okay.
So we can come back and look at that every 4 years. Yeah. All right. Any other questions from any of the committee members? Is there anyone here that wishes to be heard on this issue? Got a pretty good crowd here today. Y'all must be ready to go to lunch. Or have already been. What's the will of the committee?
Motion to pass?
We have a motion. Do we have a second? We have a motion and a second. Do we have any other questions or any other motions?
Do we need to,
Need a motion on my recommendation.
make a motion to amend lines 21 and 22 and not have them struck out, and then change the sunset date to 2022 on line 21.
That would be the correct motion. All right, do we have a second to that motion?
Second.
We have a second. Any questions on that? Do we have any other motions that wishes to be made by the committee? If not, we'll vote on the motion to amend as a committee substitute first. All in favor, say aye. Aye. Opposed? And then we go to the main question as a committee substitute as amended in a substitute. All in favor, say aye. Aye. Opposed? Good job, Mr. Deffenbaugh.
Thank you, Chairman.
Thank you, Harris.
Thank you.
While you're there, just keep your seat because you've got another bill.
I do.
Simple little bill. It's good for the children of the
Hey,
state.
this is HB 586, and it revolves around the Board of Public Safety committee, or the board itself. It has 15 members at this time, and is my mic on?
Yes, sir.
It is. Okay.
Well, I'll cut another one
It
on.
doesn't sound like it to me, but then again, my.
We can
As
hear
long,
you just,
long
we
as
can hear
it
you
works,
just fine.
okay. It's the Board of Public Safety that has currently 15 members on it, and they're requesting an increase of one more member. And that was because when the GDC board was first established, there was not a Board of Community Supervision. And since that time, the Board of Community Supervision would like a say-so with the consent of the whole board to be able to present needs that they might have that otherwise wouldn't be represented. They would be an ex officio member, and currently, let me see. Currently, that would be the commissioner, Anthony Dorlet. Am I saying the last name right? Dorelet. And he would be the member at present to be added to it.
All right. All right, questions? Mr. Petrie?
Isn't that current Commissioner Michael Nail?
Unless there's something I don't know.
Yeah, there may be some news here, Commissioner.
Let me,
Chairman, I think this is pretty simple, but Commissioner Nail, I have found to be one of the most competent and capable commissioners we've got, and so I am all in for this, and I think it's a wise move to make.
didn't
Thank
take you long to learn, did it, Mr. Petrie?
Let me make a minor correction. Anthony is the attorney for the board. And I just didn't read the right line on my paper. I do have Michael nailed. Michael W. nailed. Yes, sir. That's right. So,
Various, to the committee
my
members.
apologies to the committee and to Commissioner Nail.
Mr. Davenport has explained that pretty well in it, and I will tell you why this is needed. Back 4 years ago, I think it was 4 years ago, gosh, the time flies when you're having fun, under the Governor's Criminal Justice Reform Bill, where we created the department, we did away with parole, we created a uniform, the Division of Community Services that handles probation and parole monitoring. And at this point, or at that point, somebody, whoever the author was of that bill, forgot to put this in there that gives them a voice on the Public Safety Board. And that's what this is doing. They would serve ex officio. All right. What's the will of the committee?
Move to pass.
Second.
We have a motion and a second. Does anyone wish to be heard on this? Mr. Nail, are you good to go with this, aren't you?
Absolutely.
And more importantly, Brian, you're good to go with it?
We appreciate Chairman Powell, absolutely, very much so.
I appreciate y'all. Just in case I ever get on parole for whatever reason it is. I just want to know who my friends are. All right?
It certainly would be an asset to the board, right?
That's fine, yes, sir.
If no one wishes to be heard on this, what's the will of the committee? You've got a motion and a second on the floor. Anyone wish to make any amendments? If not, all in favor say aye. Aye. Opposed? Ayes have it. Thank you so much.
Thank you all very much.
Your bill will be in the Rules Committee.
When?
It will leave this committee, and it'll be sent, as soon as I sign the bills, it'll go to the Rules Committee. You need to go over to the Rules Committee office and sign a request that your two bills be added to the blue sheet, and they'll be eligible.
Okay.
And if they tell you they'll do it today, then you'll be eligible to appear in Rules in the morning.
Oh, okay. I will do that as soon as I leave here.
Thank you so much. I appreciate your kind
Thank
help
you.
on this issue.
I appreciate it very much, Mr. Chairman.
All right, Mr. Clark, House Bill 817.
Thank you, Mr. Chairman, members of the committee. I have LC 41-1347. This is something that, if you remember back before session started, when we had our pre-session meeting, the Georgia Association of Private Investigators, as well as the board that oversees and kind of regulates through the Secretary of State's office, the private investigators and private security firms, that they brought to our attention due to some of the changes we've made with Code Section 1611. Since private investigators are licensed under Code Section 4318, that and maintaining they have to have annual training. They get certified with their firearms and have to maintain certification with those and qualified. So they're regulated in another section, and this bill simply is just to clarify that they are regulated under another code section, not the license that citizens get through the probate court. And so that's simply it. It says as long as somebody who is licensed as a private investigator in this state, as long as they're licensed and performing their job on the duties of their job, that Code Section 1611, 126 through 127.2 does not apply to or affect them while they're performing their job duties. And that's simply this bill.
Any questions of the committee members? Tell the committee now to be sure that we're on the same wave, that this doesn't open this up for someone with a private detective's license to carry it anywhere other than authorized locations that are currently recognized under the concealed weapons permit. This doesn't open them up to the code section under 130, does it?
Not to my knowledge. Trip is here.
I'm Trip Mitchell, from the chairman of the state board. May I address the committee? Thank you, sir. Sir, from my understanding, 1611-130 would be separate and would not be affected to this. The primary purpose of the bill is to just clarify and kind of put our code section of the 21st century in more, it lines up with what we already have. So it alleviates the question from armed agencies to have to worry about what falls into place. So I think that 1611-130 would not be an issue here.
It would.
Yeah. Just like it puts them under 1611-130, it has that same effect.
All right. Well, it does not, according to our attorney. This would open up licensees under code section 130.
So it would, I'm sorry.
So what was the ruling of council?
What it will do is to have, like 1611-130 exempts all those people who are listed, it exempts them from the requirements of not being able to carry in unauthorized locations. This has the same effect, but for private investigators, where they would be able to carry in those unauthorized locations, just like those persons under 1611-130.
Which I must have misunderstood the question, Mr. Chair. I apologize. I was thinking that we were trying to actually involve ourselves into 130. The intent of the bill is not to do that. The intent of the bill is to just truly be able to allow people like armored car carriers and individuals who are providing armed security as well. For example, Georgia State, Georgia Tech are wide open campuses in the state. And if a private investigator is doing an asset protection or surveillance, they could take one wrong turn and be subject to arrest during the course of their duties. And an armored car technician or ATM operator could go on to college campus and try to fix an ATM or be with someone to empty out there. And the way the current bill status is now, they're subject to arrest. The intent is not to carry a weapon as a police officer. The intent is to make sure that when they're in the course and the scope of their duties, they're not subject to arrest by antiquated law.
So my question to council would be, do you have a recommendation on how to amend this to make sure that that 11-130 is not?
Well, I think the intent is to allow them to be able to carry in some unauthorized locations like school zones, that was just stated, in order to perform their responsibilities. So I think that's the intent.
Yes, the bills, that is the intent. It's the intent. Again, I want to clarify, security officers and private detectives are not police officers, and they are not trying to carry it, as 1611-130 points out, the laundry list of retired officers, peace officers, and those types of things. But they are carrying it in the scope of duties which would put them into public areas and public arenas. For example, you can't conduct a private investigation or, say, executive protection, a protective bodyguard, and we can't stop at the door and say, okay, we can't protect you armed anymore at this point. We'll have to go back to their car and put our gun back in the lockbox or put it in the glove box. It's really not to carry it. It's a separate permit that's issued directly by the State Board of Private Detective and Security Agencies. The original wording of the law already gives us many exemptions that's already there. All we're trying to do is just clarify certain bills, and when the rewrite of the firearm bill took place, it just wasn't included in our code. So this just kind of ratifies it all together and reconciles the information for clarification. That's the purpose.
All right. Mr. Clark, what is your thoughts on this issue about expanding this?
Well, as Tripp has stated, I mean, the intention is not to allow them to basically be treated like post-certified law enforcement officers. It's just to allow them to perform the job duties that they are permitted to under Code Section 43. I would be open to working with council to make sure that we get the language crafted in a manner that would meet the intent of the bill, as well as not expand it to where it doesn't need to go.
My interest at this, you know, this committee has ran into so much in the last few years about expanding Second Amendment rights to the average citizen.
Some people don't think we do it enough.
Under 130, that special class that's far further out than the average background check concealed weapon permitter can carry. That's become an area of contention. At what point do we not allow a law-abiding citizen to carry their weapon to the same place that we allow the clerk of a superior court, or a lot of those folks? And so my question, are we wanting to say that licensed private detectives can carry those weapons the same place that a law enforcement officer can carry a weapon?
Sir, I think it's one of the points that I'd like to make to the committee too, is unlike the normal average civilian, the reason we issue our permit is because we put certain training guidelines on any security officer or private detective that carries it. Unlike a normal citizen that can go and get the permit, a private security agent cannot go in and just get the permit. They have to go through a 16-hour training course, and they have to qualify with the weapon that they carry with, and they have to be signed off on by the agency owner themselves for liability insurance and things like that. And that's the reason why we issue a separate permit, because we want to make sure that they meet the minimum training criteria, that it's not a public safety issue to have people out here who are not trained with a firearm to be out and about. And so when we issue the permit, we want to make sure it does stay in line with what the current law is. Otherwise, it's a useless permit, because we're putting them through extra steps for compliance matters and training matters that they can qualify with, but yet they get no benefit to the permit because they have to stop at the door, or they can't go and service an ATM, which is with a contractual obligation that they have with their client.
Mr. Collins.
One of the things, Tripp, that you mentioned is carrying that weapon during the scope of their duties.
Yes, sir.
So it's not like they'd be going to a concert and be able to carry
Absolutely
their gun.
not. And we have no intention of trying to expand that to the point. We think that the current firearms bill, as far as just someone dropping off,
Right.
the law as itself is great. I mean, it does allow for someone who is licensed under Title 43, 38, 11 to drop their kid off at school, keeping it in the correct manner that they're supposed to do. There's no problem with that. But what we're saying is, if they go into their scope of practice, we want to make sure that they're not subject to arrest, and there's no confusion from law enforcement agencies or public safeties what they can and cannot do. Sure. So we're not trying to expand it to where they can carry it, in a shoulder rig and, that's not what we want. We really just want to make sure that they're covered while doing the job that they're contractually obligated to do.
Got a follow-up question, Mr. Chairman?
Yes, sir.
It seems this legislation is not only about doing the right thing, but doing the thing right.
That's
And
correct,
making,
sir.
and
That's
making
correct,
sure
sir.
that everybody knows the role of those private investigators and armored personnel. Is that what I'm hearing?
That is our goal, sir. Yes, sir.
All right. Ms. Frazier.
Thank you, Mr. Chairman. I'm listening, and you're saying that you're using the term intent, but you still want these private detectives to be able to use 16-11-130. What they're doing in there, it's just that you just don't want them to get arrested, but they're still being able to do what other officers are doing. The intent is just not to arrest them, so that they can carry out their duties.
The only difference.
So it's kind of vague the way you're saying it, but you're really saying it.
I think the only difference is in our bill is we're saying in this performance of our duties. Under 1611-130, unless I'm corrected by legal counsel, a police officer, someone in that scope of duties, can carry their firearm 24/7, no matter whether they are working or whether they are off or whether they are retired and aren't even sworn in. This particular bill specifies that they can only carry the firearm in that manner while performing their job duties, meaning they have to be working. They have to be working.
Okay.
They're not going to go and have drinks and then swing over here to the club and then go over here and go over there. That's no, we would want to not have that because we regulate enough firearms issues as it is. We don't want to open that can of worms. But what we do want to make sure, if the board get a call or we get some information, that we can clarify that the code section does allow them to do their job, as Mr. Collins said, in the manner of the performance of their duties.
Okay, but that's really not stated here, the way, what you just said.
Well, in line 14, it does have that if they're issued a permit in accordance with this code section, meaning code section 43-1810, which is the private investigator's license and permitting, that while such individuals in performance of his or her duties provided for under this chapter. So it does spell out while they're performing their job duties, and what their job duties are kind of, I mean, it's in legislation as well in the chapter. So, sorry.
Chairless, if I might call on you, do you have your annotated code with you?
I do.
You do not? Could you tell us exactly under this what we're opening this up for, licensed private detectives, where they can carry their weapons?
Sure. Well, I can't. Well, let me first say that I think, in listening, I think we also need to make clear, for example, 1611-130 does not allow for you to carry in the courthouse. The way this is drafted here, I think we need to have that same restriction applied here as well. But to answer your question, a courthouse, government building, a church, a place of worship, polling locations, and that list. If you give me a second, I can pull it up.
And those are for 130, council?
I'm sorry.
Those are, the places you're listing are for, that's in 130? The churches and,
No, that's in, I think, 1611-126.
correct. So I mean, that would be what we're getting at.
127.
Okay.
So yeah, the places in 127 are government building, courthouse, jail or prison, place of worship, state mental health facility, nuclear power facility, and yeah. So that's what you would, that and the school's safety zones as well. And that's K through 12 and
All right.
colleges.
To the author of the bill, is it your intent to try to expand it to all of those locations?
My intention is to allow them to perform their jobs. So if they're working, if a church wishes to contract with a private security firm or to allow them to do security on their campus, I would be open to allowing them to do that, where they could then still restrict just public, because of private property, they could say no guns allowed on the, except for, they could restrict somebody with a probate license from carrying, yet hire private security to provide security at their church. I would be fine with that. So I think as long as they're performing their job duties, so that would, so they couldn't just carry onto a nuclear plant if that nuclear plant doesn't allow them to. They would have to be, or does that make sense what I'm trying to say there?
The ones that stick in my mind are courthouses and the more prohibitive locations, courtrooms, those type of deals, schools, K-12.
But they wouldn't be performing their job duties on the school or in the courthouse. Well, unless they're going to testify, I don't know.
Mr. Chair, if I may add, really the foundation of this was schools, courthouses, and colleges have ATMs. And they do armored car pickups from bookstores and those types of places. Right now, the way the law looks is that an armored car industry owner who contracts out with Georgia State Bookstore, Kennesaw State Bookstore, another bookstore, they can't carry their gun onto the premises to service the ATM or do a cash pickup.
Sure they
So
can.
not under, well, because we don't have the exemption here, sir, under the 1611, 127.1 and .2. That became a point of clarification.
So that's where some of the private eyes were saying that they're under more restrictions than a normal citizen with a concealed weapon permit.
Yes, sir. That would be
All
part, and
right,
even
let me make a
courthouses.
suggestion, if I might. If the author would get with Julius, let's see if we can clarify, stream this thing down. And if you need somebody to work with, why don't you work with Mr. Petrie?
Okay.
If you feel like you gotta have somebody to work with to move that on. And,
Yes, sir.
And if you'll get that ready, we'll add that one to Mrs. Rakestraw's. And then I'll call a quick meeting when all of this is ready. I
Okay.
think what we're looking at is I think we still need to bear in mind that we've got some concerns about schools, K to 12. That seems to be where people get nutted up the worst about opening this up, even though, and if it's the wishes of the author, if he wants to just basically open it up to the terms of 130. But I would caution you that it might not move out of rules if we do right now.
Yes, sir.
So, but if you would, let's rehash this with Julius and just have it ready for the quick meeting.
Okay.
All right?
All right. Thank you.
Thank you, Mr. Chair.
Mr. Chairman, I have something else to
Do we have someone else wanted to speak to this bill? Yes, sir.
Mr. Chairman, and this is not our issue with GMA at all. I just wanted to point out something, and maybe Julius can double check me, but I think the way the law is currently written, these folks could already carry within the courthouse and government building scene, because if I'm reading this correctly, the current law says an individual issued a permit in accordance with this code section shall be exempt from the following laws of this state, and then paragraph 2 says code section 1611-127, which is the courthouse and government building thing. So I think at least with courthouses and government buildings, they were already there. This would just take it to the school and the nuclear power plant, was my reading of it. So just FYI.
That's cool. We don't want to take anything away. We just want to clean up wherever they can go.
Yes, sir.
Even though, like I said, that K to 12, as we know, that's the one that seems to ferret out most concerns. So,
Okay.
good deal. All right. We're not going to table that. We're going to suspend action on that one. All right. And then, Mr. Collins. Yes, sir. House Bill 774.
Thank you, Mr. Chairman. Working on LC 41-14007S. We heard a good bit of testimony in the subcommittee last week. This is the bill dealing with the booting of vehicles here in our state. As many of you know, we've had a lot of issues from the good folks around the state who have been booted. And there've been a lot of miscommunication and a lot of, quite frankly, abuse from some, but not all, of the companies that boot. What this legislation is going to do, Mr. Chairman, as you well know, will just provide a blueprint for municipalities, whether it be county, city, that want to have a booting ordinance. It lays out some specifics. I'll go through the bill real briefly. If you'll look in lines 72, 73, there won't necessarily be a board to oversee this. We're not trying to create a lot of bureaucracy, but we are trying to create a level of transparency and accountability where booting is concerned. There's a fee that would be paid to the Secretary of State's office to register as a booting company. If you will go on down through there, you can see some do's and don'ts that operators shall do and not do. If you'll go over on lines 112 and 113, it talks about the services 24 hours a day, 7 days a week, that they shall maintain a phone number. So if you get booted and you want to call to get your car unbooted, we're all going to require in this legislation, if it should pass, that they have personnel and staff there that can take your phone call 24 hours a day, 365 days a year. That's just consumer protection, ladies and gentlemen. Some of the stories that we've heard are horrific stories where you've had blatant abuse and people waiting in lots. And, you know, I think about my grandmother who passed away a few years ago. She loved to go shopping, and she had knee problems and heart problems. And I can only imagine what would happen if her car had gotten booted in one of these lots on her way home. So I think the consumer protection element of this legislation is much needed throughout the state. If you'll skip on over, you can see that it lays a footprint for some fines and fees associated with the booting in lines 148 and 149, that general area there. Also allows for, you know, if it's left over 24 hours, parking fees and those kind of things can be charged as well. Skip on down into lines 157 through 164. It talks about signage. One of the things I think that we heard is there needs to be proper signage where these companies are concerned. You know, as you travel throughout our state, you see speed limits. You see things you can and cannot do, rules of the road that are posted clearly and visibly. And I think that if you're going to be in that business of booting cars, that it needs to be clear and visible throughout the state. So that again adds to the blueprint. And then if you'll skip on over, ladies and gentlemen of the committee, you'll look on 168 through 175. There's just some more verbiage there to talk about the signs and the things that are necessary if you're going to boot. We worked with GMA and ACCG to get the wording there. And I would also like to add that just before this meeting came, we wanted to add a piece of verbiage. And Julius, if you'll help me out with this here, please. We want to strike out on line 201 after chapter. After the chapter, we want to strike out the rest of line 201 and all of line 202 there. But we do want to add some language at the bottom to say including but not limited to prohibiting vehicle mobilization services within the jurisdiction. So we want to be able to give local government an opportunity to say, hey, if they don't want to have booting, they don't have to have booting.
I might ask council, by striking that language on 101, 102, is that necessary to achieve what we want to do, or does that need to be left in there and then add the language about if a local political subdivision doesn't wish to allow booting, that they can state as such?
I follow you. I think that is correct. What we'll do is after chapter line 21, say including but not limited to prohibiting
Vehicle mobilization services.
right. And then we'll have provide however that they shall not adopt anything that conflicts.
Right. All right. Just do it, leave the language there, that a county or municipal corporation shall not adopt any ordinance that conflicts, period. And then add that phrase in there about the local governments.
Mr. Chairman, if that's what legal counsel thinks we need to do, I'm just a country undertaker, so I'll have to defer to those who are a little bit more
understand.
intelligent than myself.
And if I might add, Rishi, do y'all,
I think that makes sense, because then it explicitly allows the local government to prohibit them, but says that we can't.
just point blank, the language that says that if they wish to prohibit booting, then they can do so.
That makes sense to me.
All right?
I think that's vitally important coming from local government. I think local government
Right.
needs to have that ability to do that.
Was the lady that was with you earlier, is she still here?
She just left, she had to go to another meeting.
She gonna trust you to stand in for her?
I'll trust.
Oh, I'm sorry. Let us all stand. Todd is in the room.
Well, you did inquire on ACCG. We've been working together with GMA and the office.
Does that language suit y'all, Todd?
It's so stated by the distinguished representative of the Georgia Municipal Association.
This is an interesting day that GMA and ACCG are actually holding hands and singing Kumbaya at the same time.
The way I would look at that is that by adding the clause in that says we can specifically prohibit, that's no longer conflicting with the chapter then. And so that way we can still be able to do that. So I think that makes sense.
Right, it makes sense.
All right?
And what I would suggest doing is making a new subsection A, where it says a county or municipal corporation may adopt an ordinance, and then there'll be subsection A. Subsection B will be that, will state that, a county or city, may prohibit mobile vehicle immobilization. And then subsection C will say that, they shall not adopt anything contrary. That
Right.
kind of separates it out and makes it clear.
Good deal. All right. Is there any other changes to the committee members that, well, I see the lights are flashing. Mr. Petrie?
Mr. Chairman, I might try to get some history from you. Maybe you can help us to understand. I don't have any problem with this. I cannot tell you the number of people I've talked to over. Is there anybody here that represents these booting organizations here, by the way? I'd love to know that if there is, just out of curiosity. I have seen so many abuses by these organizations, and this is someone's private property that is being encumbered. And I was going to ask you, first of all, Chairman, what is the history of these organizations and their ability to operate in the state? Because we're talking about doing some unprecedented things here. We are talking about capping what someone can charge. We're talking about a pretty egregious fee, annual fee. I would almost never support that for any reasonable business in the free market, but this is different.
Kind of business.
This is a different kind of business.
Yes, it is.
And so I'm interested in the history of someone that maybe has a little more time up here to help me understand how we've regulated this in the past, because I have seen terrible and egregious examples of this, not only in Savannah, but here in Atlanta especially as well.
Well, Mr. Chairman, if I may, during some of this testimony and some of the things I've heard, I think that there were members of this industry who are doing it right that don't want to be painted with that broad brush of those who are abusing this system. And they've asked for some type of legislation that would bring some accountability and credibility to that profession. Because I think no matter what profession that we have here in our state, you have people that are doing it right, but some that don't. And so I think that they want to take some steps to mitigate what this body would do, given the fact that these complaints are rising in severity against our constituents and the people of the great state. So I want to say that that's what I've been educated upon, going to some of these hearings and being a part of some of these conversations. If I'm wrong, Mr. Chairman, please
You're
feel free to
absolutely
correct me.
right. And I'll add just a little bit to this. The history of this, to my knowledge, over the last 30 years, that the General Assembly really has never dealt with this, except maybe just on an occasional blush. We dealt with certain things that were mostly here in the metro area back in probably 20 years ago. But I really don't know of a whole lot that's been done since then. Representative Collins spoke right. The industry, and I perceive probably the more positive folks that are in this business came forward. and they wanted to see their industry regulated to the point of putting all of these, the do's and the don'ts, because they understood, I think that those people who came forward, they understood that right now that there's people that are out there doing this type of a practice that's on the verge of probably having us ban the whole practice. Now, I'm not much about one that bans anything. I think there's a purpose for all of these things. I think in the realm of parking and people parking illegally and things, that there's probably a purpose for the booting that's probably better than having it towed. But at the same time, we've also heard the stories from around the state. There's no uniformity. So you might have someone down in, well, it's like I'd spoke last week about the police officer from Noonan that called to thank me for entertaining this bill. And he said that they had two AT&T trucks that stopped for lunch, walked across the street to McDonald's. Both of them got booted to the tune of $300 apiece.
Yeah.
There was an RV that got booted to the tune of several hundreds of dollars, $500 or $600. A tractor trailer was booted. At our last full public safety meeting, GBI agent was in attendance here. He parked across the street at that the pay parking lot and forgot to put his parking decal on the dash of the car. He put it on the console. He walked out and he was booted. We've heard stories. We've heard stories about folks be sitting in the car waiting on somebody, and somebody boots his car while he's sitting in the car. I mean, it's just something. This is more of a consumer piece of legislation that's been asked for by certain people in that industry, by several members that are in that business, and they want it cleaned up before something does happen, like it just rankles the taste buds of legislators that we just ban the whole thing. As we had noticed at that last meeting, I didn't realize until that testimony that we had several political subdivisions, cities and counties, that banned it altogether in their jurisdictions. If that's their wishes, and that's the reason I want to be very particular that we allow the local governments to deal with this. So, that's the gist, the genesis of this.
Question, Chairman?
You
That was
certainly
very
may.
helpful history, and you went right where I was going. I want to make sure we're correct that we're allowing locals. We're not preempting their ability to ban this altogether. But I'll tell you, you could make a good case to ban this practice everywhere. Quite frankly, I'm not doing that. But I would ask my friend Mo here, if you represent some of the good guys, I know there's the good, bad, and the ugly in my business and in every other industry. Is it true then, having heard the chairman, Mo, that is there an association of these individuals that have formally requested this type of legislation? So I'll understand.
Absolutely, sir. I'm Mo Thresh, I represent the coalition of the Towing Association. And Chairman Powell told it just like it is. The association came forward to do self-regulation. They need regulation. There's some bad apples out of this state.
Yeah.
That you heard the stories. He told exactly like it was. There was a case of hundreds and hundreds and hundreds of dollars being charged of a booting of a tractor trailer. And we're coming forward with state regulations. Same prices cannot be charged more in Hayhire than it can in Blue Ridge, all across this state. You self-regulate, and in this bill that Representative Collins just told you about is listed in there. There are now approximately, I'm gonna say 20 booting companies throughout the state that do it right. But there are shysters all over the state.
Right.
Need state control. And this is the only way we see forward to do it.
Gotcha. Well, I commend your association for just that. It helps me to know that. And because this is, as you would understand, typically guys like me would not support these kind of constraints on the private sector. But this is completely different. These are people that are inhibiting individuals from using their own property. And I have a real problem with that. So I commend you for this.
Mr.
Thank you, Chairman.
If I can make one more comment, and just so you understand too, Representative Petrie, this legislation is not just, beating up these companies. If you look on line 139 of the bill, if you're booted and you try to tear that boot off yourself and you damage your car, that's on you. So there's some things in here that will also protect some of these legitimate operators as well, and service providers that add some protection for them as well. So this just didn't kicking the crap out of them altogether.
Ms. Frazier.
Mr. Chairman, you all have answered 2 or 3 of my questions, but I'm with my colleague, Representative Petrie, about the amounts of these boots. Is there any standard amount, maybe this is for Mo, any standard amount for booting? And where does this $85 just come from out of the air? Because I had the same problem with one of my constituents that came actually to the Capitol, parked across the street, didn't put the ticket in the right place, and she got booted. Well, she didn't have any money, so I had to use my credit card to get her unbooted. And it was close to $100. Where are these amounts coming from? And then how much money does this industry make with these bootleggers that you say aren't following the rules and regulations? How much money is generated here? Because this, to me, seems like we're being taken advantage of. And then, Mr. Chairman, I know we're going to probably pass this, but I like to make a recommendation that we reduce these boot fees.
Well, if
Mo.
May I speak, Mr. Chairman?
You certainly may.
I think we're requiring some things of the booting companies. If you look through the legislation, they have to have liability insurance.
I see.
They have to have that. So, when you start looking at what it costs to operate and maintain a business, when you take your labor considerations into effect and just the cost of doing business, the $85 fee is not that far off from a tow bill. Understanding that a tow bill may be more, obviously, because you have a wrecker, you have to have a lot to carry it to. I mean, so I think the $85 fee is not that far off.
I understand that also, but these fees are based upon your vehicle, the size of your vehicle.
It's $85.
This $85 is that a flat fee?
It's a flat fee
for a bus as opposed to a regular car? Because I'm just hearing from up here that fees have been a lot more than that.
I don't see anything in this legislation that says there'll be a graduated fee for the size of a vehicle. I mean, there's not. There is not.
Okay. Still want to reduce them, Mr. Chairman.
Mr. Chairman, can I reiterate one important factor? First of all, this is private property booting only, on private property. If you park on the city of Atlanta streets, that's public, they boot all the time. This does not affect them. This is private property only. If you get towed by a tow truck in this city or in the state, they're gonna tow it to a lot, like he just said it. Representative Collins just told it like it is. And I promise you this, it's a lot more than $85. And the hassle is a lot less. He mentioned in this legislation that you have to have a representative from that company on call 24/7 to come and take that boot off. You can't go to a tow lot and get your car off that tow lot. Well, you can do it if you have your title in your pocket and walk onto the lot and get your title, show them your title and get your car off by paying a lot more than maximum, not to exceed $85 for a boot. So that's why we're bringing self-inflicted state regulations on the industry, because it is needed.
As I'm sitting here and I'm listening, I mean, we've got an opportunity here to probably make a better bill out of this. There's a couple of things that just struck me. One, and you were talking about your friend that got booted in the same lotto here. Now, the GBI officer, once he confronted him, showed him his ticket. Then they pulled the boot off of his state car. What happens if, like your friend, if she had paid her parking, if she paid her parking fee, and it was paid, just because the ticket was, say it had blown off the dash, but she had legitimately paid her parking fee there. what is the alternative? Do you mow? Can y'all answer that question? Somebody boots your car, but you've actually paid for in a parking space for that parking. What do they do at that point?
I'm sure you can show proof of that, Mr. Chairman, that you.
I mean, that's something that I think needs to be looked at to be sure of that. And secondly, there's something that and I'm sorry that Mr. Holcomb is not here, but he brought up something in that subcommittee that I think it probably needs to be addressed, and that's when you are putting parking in a shopping center or a public place where you have multiple stores. Right. And I think what he said was, and y'all heard it better than I did, but he got booted.
He went from one business to another.
Yeah.
And
if I pull into a parking space, if I pull up into a shopping center, and I go into one store, and I leave that store and I go to another store, this zone it was almost like they were doing zoned booting, which is kind of a distasteful subject to me to be doing that. Is there any language, was there any consideration in the subcommittee to look at language that would cure that problem?
Well, I think we all understand that that's a problem, Mr. Chairman, but, you know, like everything else, I mean, you can only go so far with legislation. And while I certainly understand exactly where you're coming from, and I think in the testimony that we heard, you know, this is a good first step in protecting the consumer and creating some accountability for an industry that really has no you know, level of accountability and credibility at all right now. So while I certainly would be open to that, I'm not sure how you would be able to regulate that. You'd have to.
Clark.
Thank you, Mr. Chairman. I remember in our previous meeting, it was mentioned that there are, I mean, we're trying to clean up this industry altogether before it gets outlawed, and there were some people here testifying to outlaw, and they had some actual instances where an individual in a neighborhood, a subdivision, had failed to pay their homeowners association fees, and they wake up, and I mean, this in their own house, on their own driveway, and they walk out to their car, and it has a boot on it. So I see in section 123 through 120, or lines 123 through 126, where you have, it shall be unlawful for an operator, and it kind of goes through private property for the lot, but could we add some language if we're talking about amending to make sure that they cannot impound a vehicle on its own, on private property of an individual? Do you see what I'm saying? Like, I mean, well, I mean, it says, the way I read it is property without having entered into a valid written contract for vehicle immobilization services with the private property owner. So would that exempt them from going on to somebody's personal private property at their house in a homeowners association? Because the way I'm reading that, that's for like parking lots. Like, you can't just have somebody who owns a booting company go into a parking lot for another company in.
It sounds like where you're going is that you want a specific provision to state that if the property is being used as a residence of some sort, that even though it's like you have the apartment complex, you have the owners of the apartment, but then you have the person who's leasing the apartment. In that situation, you want where that's a residential.
Correct. So like.
They cannot boot any cars for someone who's leasing or who's residing in.
Well, I guess where I'm being careful with that would be like somebody who owns a condo, like especially around like in cities, you have apartments or condos, and they actually own that parking lot as well. So if you fail to pay your rent or your condo association fee, then yeah, I guess they could, because that would be.
Let me walk you through this here. Like, take for instance, I live in a townhome community in Villa Rica, and the street's private property. It's not a public street. So if I don't pay my HOA dues, I believe what Representative Clark is saying here, if I don't pay my HOA dues, my HOA should not be able to boot my car in my driveway. And we want to prohibit that.
Yes.
Prohibit
Correct.
that.
As currently drafted, I don't think it reaches that, so we will have to insert language to address that.
Okay.
Let me make a suggestion, because we've got a little time, and I'm gonna be calling another call meeting on this. Mr. Clark, would you work with, Mr. Collins and Julius, and let's address that? I'd also like to see one part addressed in here that says that, basically the old line that your defense should show that if you're at some place and you show that you have the right to be parked there, which would be by virtue of your parking ticket that you paid that.
If you can produce a receipt or some type of payment,
Yes, that if you once shown that, that boot would be removed.
at no cost to the,
Ms. Frazier, how does that tickle your fancy? You like that idea? I mean, if we're gonna do something that's gonna be to the benefit of the consumer out there, let's address these issues and let's go ahead and get them done, if we're gonna put it in there. And if y'all would be kind enough, maybe, to speak to, gosh, I called his name just a minute ago, just not here today.
that's Representative
Holcomb, to see if he wants to weigh in on that part about parking lots. Something about the idea that if I pull up to a parking lot at a shopping center or whatever, and I walk into a CVS store, and then all of a sudden I'd say, well, I'm just gonna browse and I'm gonna go down to the next store 2 or 3 windows down, and then I come back and my car's been booted. Ooh.
maybe a
Ooh.
30-minute window of,
I'm not sure just if that the whole parking lot ought to be, but if you're there shopping, you've got rights to be there.
Chairman, there's a couple things I'd like to add as well.
And
I'd like to mention a couple of things. If Mo, if you guys could help us with this. I agree with Representative Frazier. We have in this bill an $85 fee, and I appreciate your comments you made. But where did that come from? I would like to see some data to show me where the $85 figure came from. What justifies $85 over $75 or $95? I think before we make decisions like this, we should have some data. So I do, and I would say one other thing as we work this through, because obviously it needs a lot more work. I would say that, quite frankly, in my opinion, we should amend this by removing lines 139 through 143 altogether, to suggest that if a person with their own private property will be responsible for damage done to a boot because they try to remove a boot off their own property is inappropriate in my opinion. That should be removed altogether in my opinion. But I'd like us to discuss it further, so let's just consider all of those points of conversation.
so let me make that clear. So if I'm in violation and I've got a boot on my car,
You're in violation, what does that mean
and
exactly?
I'm in violation, I come back from dinner with my family, and let's make this clear.
There's a boot on your car.
There's a boot on my car.
Perhaps
Well-
inappropriately.
Well, appropriately, inappropriately, but let's just say that I'm in violation. And I try to remove that, or I try to back my truck up or car up, and it does $5,000 worth of damage.
Let's say you didn't know it was on there. What you're saying here is that owner is completely liable. Why?
I hadn't looked in here.
Why should they be? They didn't put it on their vehicle.
I might ask, somewhere there, didn't we put in here that, isn't there somewhere in here that
Yes.
that booter has to put a decal on the window?
There has to be proper signage there. There has to be a sticker on the car.
Sticker, no sticker. It's private property. Somebody put a boot on it, on my private property.
I just.
I'm with you. I mean, we're trying to get to the same goal. I mean, I appreciate what you're doing. This is an admirable bill. I'm all in.
We'll have to work on that, but
I'd like to make it better.
Let me just ask y'all, since it's such an admirable bill, do y'all have time this afternoon to sit down and work on this? Have you got any committee meetings you've got to be at?
I have a 3 o'clock meeting, 3 to 4, and then I'm free.
4 o'clock?
Sure.
4 o'clock?
I'm gonna be spending my afternoon with Julius anyway, it looks like, so.
It's better than spending an afternoon with me, I'm sure. Julius, would you be able to work with these folks to see if we can get this cleaned up? So be it. We're gonna suspend
3
this
o'clock.
and, we'll pull this one out of the,
Where we gonna go? 3 o'clock?
Oh, 4 o'clock, 4 o'clock, I'm sorry.
wherever y'all,
4 p.m.
you're the new subcommittee chair, where would you like to meet at?
You wanna meet in can we meet in your office?
You can meet in the conference room in my office.
I've got a
Alright.
little office, I don't.
Suit y'all?
Yes, sir.
Conference room.
Matt, good to have you here. You've got awful good common sense. Would you like to weigh in on this? Or do you think?
I've experienced the same thing, Mr. Chairman. I was at a shopping center, left my car there. My wife and I walked across the street to get something to eat. We came back, we had a boo
Tell you.
People were nice enough to remove the boo after they found out we were shopping.
Yeah, it's.
You lost a lot of time, though, didn't
Specific to that,
Yeah, there were a lot of arguing.
Lost a lot of time.
yeah.
Your time.
Very good, all
Your
right.
private time.
Is there anything else that anyone wishes to bring before the House Public Safety Homeland Security Committee? If not, this meeting stands adjourned.